Welcome to New Jersey Divorce Talk Radio, fostering the growth of collaboration through shared resources while empowering families to divorce with dignity. This is New Jersey Divorce Talk Radio.
New Jersey Divorce Talk Radio is brought to you by the Collaborative Divorce Professionals Practice Group, independent interdisciplinary divorce professionals serving Monmouth, Middlesex, and Ocean counties. For more information, visit njcollaborativeprofessionals.com.
Welcome and thank you for listening to New Jersey Divorce Talk Radio. Our mission is to inform, educate, and empower families as they navigate through divorce. In this episode, we are talking with Anna Maria Pitella and John Caroli about divorce and privacy issues. Anna Maria Pitella is a family law attorney in Red Bank, New Jersey, with over 40 years' experience. She is one of the initiators of the family collaborative law movement in New Jersey that culminated in the passage of the New Jersey Family Collaborative Act on December 10, 2014. John Caroli is a certified financial planner in New Jersey who works with divorcing couples either as a neutral financial advisor or as an advisor to one spouse, if that is needed, to resolve financial issues that arise during the divorce process. Anna Maria, John, welcome to the show.
Thanks, Dustin. Good to be here.
Thanks for having us.
We're talking today about the idea of privacy and divorce. I know that the concept of privacy seems to be foreign to people today. With social media, our culture seems to almost embrace transparency. When it comes to divorce and privacy, we often see the implications played out in the media. You know, people's celebrity divorce is all over the media, and but this is really something that is relevant to everyone. I know that no one wants their dirty laundry aired before the public, but I know that for most people, privacy is a concern, but they may not think about it when they're first entering the divorce process. I was wondering if you could maybe tell us a little bit about what are some of the issues involving privacy and divorce.
Sure, Dustin. So for most people, I don't think they really consider what happens when they file for divorce. Once the complaint is filed, your matter becomes an open book, so to speak. There are some certain court rules that require some information to be removed, such as Social Security numbers, bank account numbers, credit card numbers, but it doesn't do anything as far as removing the words that are used in any paper that's filed with the court. So there's mudslinging, then that becomes public record. If there's information referencing addictive behavior or any type of difficulties between the parties that are out of the norm, that's all public record. So it's pretty interesting fodder for anybody who takes the time to look into it. Needless to say, the one person that's the normal person that doesn't have a lot of notoriety is not going to be the ones that the newspaper is going to look for. But interesting facts make interesting reading. So there's always a possibility that something can surface and you really don't have any control as far as keeping it out of the newspapers or any type of media unless someone goes to court to ask a judge to curtail that. So you're basically on the defensive rather than the offensive to contain that information.
So is it just the final divorce settlement that becomes public record or the whole process?
No, right from the get-go. So if you file a complaint for divorce on the grounds of adultery or extreme cruelty, all that information is public record.
What if you have the situation, I'm thinking that this can go beyond that too, even to non-parties. Am I wrong? What if one of the spouses is involved in a business and they're have a part ownership in a business and there's discovery involving the finances of that company? I would think that there would be privacy issues involving non-parties in that case. Would that be?
Sure. The owners of a company, if they both have interests, are part of the same enterprise, so you can't just cut out one business owner from the process of finding out information that might impact on the finances of a couple. So John's a financial person here, so I'm sure he's seen situations where there is that intertwining, and it's very sensitive.
There are plenty of times when you wouldn't want your, like you said earlier, your dirty laundry done in public. And a business valuation is a classic example. You could be in a cash business, and in a collaborative case, the couple can stipulate that the income is $80,000, for example, where your tax returns might indicate something else. And I don't advocate that, but it is private, and that's part of the process and part of the. You don't want other people knowing how much you make. I don't think. You might have competitors as a financial advisor or as an attorney. The people down the street, you don't want them to know whether you make a lot or a little. I don't think you want them to know whether you've amassed a lot of assets or a lot of debt. Really nobody's business.
Now, in a traditional divorce, are there any steps that the court can take or that you can take to ask the court to protect someone's privacy in that situation?
You can ask for the record to be sealed, but the interesting thing is that everybody feels that their matter is private and should be sealed.
Of course.
The court, however, feels that there are very unique situations that require the sealing of the record. So the majority of people don't fall into that category. If you're going to have a highly public divorce, both parties may not even agree that it should be kept private. There may be some benefit for one of the parties to have it made as public as possible. So there's difficulties right out of the get-go to even get to the point where a judge will decide that it is a case to be sealed, a record to be sealed, or that the parties will fight hard to not have the judge seal it. In a collaborative divorce, you're right from the signing of the participation agreement, ensuring that your process is going to be confidential, that it is going to be private, and the people who are entering into this process are doing it many times for that very reason, because they understand the value of keeping their information out of the public eye. You'll see a lot of celebrities. Robin Williams had a collaborative divorce. Gwyneth Paltrow didn't exactly have a collaborative divorce, but they had what they called a uncoupling, but it was done very privately, very confidentially, with their children's best interests at heart, frankly. And that really is the impetus for this type of a process.
So the solution to, or the best way to protect your privacy in the divorce process, are you saying that it is collaborative process?
Absolutely. You have two attorneys representing the parties. You have a financial neutral that works with the parties. You have a divorce coach who manages the emotional factor of any divorce. Parties are assured that there is going to be full disclosure in a collaborative process. So we don't need to go to court to force people to provide financial information. They understand they have to provide it right from the beginning, but they're doing it because they realize it's also going to be cloaked in confidentiality and it's not going to be released as a public record. So they're getting the benefit of having that full disclosure, but at the same time keeping it very private.
So in the collaborative process, the process of negotiation or the meetings that you have, the disclosure of financial information and other information, that is all kept private. But does any part of it ever become public record?
It doesn't have to be, because actually you don't even have to file the final marital settlement agreement that you reach. You have the right under the rules to reference it in the final judgment of divorce, but it does not have to be filed. People can decide at that point whether they want to or not, but the whole process of discovery in terms of exchanging financial information is kept private.
Now compare that with the traditional divorce. You said that one or both couples might petition the court or ask the court to seal the record. How often does the court do that? I guess they've got to have a pretty good reason. Isn't that
Extremely.
Yeah, because aren't they, the public accessibility of that information, isn't that a constitutional right, I believe?
Well, it's not so much. I'm not so sure that we want to go about it on constitutional grounds, but the value of it is that it's a court filing, and court filings are open unless the court deems that they shouldn't be. So typically, the types of files that are sealed are those that may have some, for instance, in a situation where there may be some sexual abuse of a child, that would be sealed because it's obviously in the best interest of the child not to have that information made public. But generally financial information, unlikely. If we were talking about a company that had a trade secret, maybe that portion of a case might be sealed, but not necessarily the entire proceeding. It's a very case-by-case sensitive decision that a judge has to make. And it costs money, lots of money. So all of these applications are going to cost thousands and thousands of dollars before you even know whether or not a judge will agree.
Now, I read that in 2012, Katie Holmes and Tom Cruise did some sort of a confidentiality agreement, a confidential settlement. Is that similar to what you were talking about you end up with through the collaborative process?
It can be, but not exactly in the sense of a process. That may be something that you may agree to when it's all said and done, that neither party can disclose the contents of an agreement. That's not a collaborative process in the sense of having that cloak of confidentiality as you're doing all of your negotiations.
Okay. And so in the collaborative divorce, you're not going to have the other problem of one of the spouses going on social media and bad-mouthing the other one or trying to spread information to posture their case or what have you. It
would basically fly in the face of the whole concept of confidentiality. So I've not seen that happen, and I assume I will never see that happen.
What about divorce mediation? Is that is that a comparable solution for protecting your privacy in divorce?
It is in the sense that you're doing it away from the courthouse. The only problem with that is that you're not necessarily having the same pieces that are offered to you in a collaborative process, and there's no component of a mediation process that encourages people to stay in mediation. Each one of them can leave the room, so to speak, and hire attorneys and go to court. So in a collaborative process, even though you have the right to go to court, the premise is that we're staying here and we're going to continue to stay here until we reach a full and final settlement agreement. And you have attorneys, a financial coach, and a divorce coach all helping you to stay in that room. In mediation, you have the mediator who can obviously strengthen that commitment, but it may not be as forceful as in a collaborative process.
What happens if the collaborative process breaks down? And I know that if that happens, that the couple has to hire new attorneys because they have agreed that the attorneys in the collaborative divorce, if it does not reach a settlement out of court, that they won't continue to represent them. Is the information that or the content of those meetings and negotiations that they had, is that confidential by the initial agreement?
Absolutely. Okay. It's by statute and by the actual participation agreement. So whatever information has been provided, exchanged, or obtained in a collaborative divorce stays with the collaborative process. The parties can't take the files, can't take the information. Maybe they can secure that information in different ways in a litigated divorce. But again, they're right back to where they started, where they're fighting between each other to obtain that information, and a judge has to decide whether or not it's going to be admissible.
You know, this issue of privacy is certainly really important. As John was saying, especially when it comes to, when it comes to everything, but when it comes to finances as well and financial information. You mentioned that a lot of people don't think about it. When folks come in and they're facing a divorce situation and trying to figure out which direction to go, is Is that not usually a concern they have, or do they not realize how much of this information may become public record?
Well, John's gone through a collaborative divorce. I'm sure he can speak a little bit about, why was it important to him to have the confidentiality in his process?
Yeah, sure, I can comment on that. My divorce was collaborative, and it was not very interesting, I don't think, to the media. Nothing interesting was involved in it.
Yeah.
And yet, I appreciate my privacy. My ex-wife and I went through this process not for privacy, but I grew up in Fairhaven, and there's lots of people in Fairhaven and Rumson and Navesink that might take an interest in what my income was or hers or what our assets looked like or any other aspect of our divorce. And it just ain't nobody else's business. So I was pleased that it didn't become fodder for the local rumor mills.
Well, the mudslinging that can take place during a divorce when it becomes adversarial, can be far-reaching. I mean, it can impact personal and professional reputations. There are just a lot of issues that go along with that. So I think that it's certainly something that someone should really consider as a reason to go with the collaborative divorce process over the traditional route, for sure.
Yeah, so I think that's what we see the most, that people realize how much damage they can do to themselves, do to their children, and to avoid that, really, the best way is to get into a process that isn't going to encourage you to look for solutions for the future without continuing to blame each other because of what the past has been between you. Really, it's what we're looking to do is make sure that the family comes out as a whole and protect the information and provide it as best as possible.
Okay.
And I think that successful results for anybody going through a divorce.
So if someone's listening to this and they are considering divorce, they can acknowledge the importance of protecting their privacy as well as many of the other benefits of the collaborative divorce process. What should they do next?
Well, I would suggest that they look into the professionals who can provide that service. Collaborative divorce professionals are obviously a group of individuals who have made the commitment to support and promote collaborative process, and any professional in that group would be happy to provide a consultation on the benefits of this process for that person's family.
Now, Anna Maria, your practice is your primary focus is the collaborative divorce process. Is that right?
Correct.
And John Caroli, what is your role in the collaborative process?
Typically, I'm engaged as a financial neutral, which means essentially translator. I would help create an asset inventory and look at their incomes and their credit cards and their bank statements and that sort of thing, and come up with a budget both before and try to come up with what it might look like after divorce, and then support the attorneys in coming up with an agreement that would include equitable distribution, alimony, and child support if children were involved. Like Anna Maria, I would be involved as a neutral person. She would advocate for one client, one spouse. But after, I would not be allowed to work with either of them.
Okay.
Because I didn't want me to have any bias.
Well, thank you very much. Go ahead.
I was just about to say, and John's very modest because he's an integral part of this process. There's generally one spouse who has more information than the other spouse, and his ability to translate, as he calls it, gives them a level playing field so that both parties can feel that they're making good decisions for their future.
Absolutely. And that's what it's about, honestly, isn't it? It's about getting through this process and then looking at the future.
Right.
Yep, confidentially, privately, and with a productive purpose.
Well, Anna Maria Pitella and John Caroli, thank you so much for talking to us today. We've been talking about divorce and privacy and some of the issues surrounding that and how to protect yourself during divorce, how to protect your privacy with the collaborative divorce process. If you're listening and you'd like to get more information, maybe contact Anna Maria or John, You can find the show notes and their contact information at NewJerseyDivorceTalkRadio.com. Thank you for listening, and we'll see you again on our next episode of New Jersey Divorce Talk Radio. Thank you.
New Jersey Divorce Talk Radio is brought to you by the Collaborative Divorce Professionals Practice Group, independent interdisciplinary divorce professionals serving Monmouth, Middlesex, and Ocean counties. For more information, visit njcollaborativeprofessionals.com.
New Jersey Divorce Talk Radio, empowering families to divorce with dignity.